This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. I'm Stuart Address, and this is Ask a Lawyer for the first show of 2020. We've been doing this for almost 2 years now.
Yeah.
In February, we'll go into year 3. It's hard to believe.
Yeah, you're just flying through.
I feel like I've exhausted all the topics I could possibly discuss.
Yeah, right.
Not.
I was going to say, you haven't even hit the tip of the iceberg. Are you kidding?
So I hope everybody had a great holiday. Christmas, Hanukkah, New Year's. I'll tell you, I went to a Hanukkah party at a friend's house, and they did one of those Secret Santa exchanges. And my girlfriend got this large pink purse,
Okay.
which she did not like, and nobody would steal from her.
Yeah.
And nobody would trade with her.
Oh,
So I
man.
decided, in an effort to assist her, I guess I'm never going to become a member of the Supreme Court. There's too much video out there now.
Yeah.
I took the pink purse, I put it over my shoulder, and with the walking boot I have on my left foot for my partially torn tendon, I did a runway strut across this person's living room with the pink pocketbook.
I want that picture. I want that picture.
There's picture and there's video, and it's not pretty.
Oh, my God.
But it was very funny.
The ultimate blackmail shot.
No, look,
Yeah.
there are probably people that have plenty of those for me.
Oh, boy.
I don't pull any punches. And I had not had a single drink, let the record reflect.
Yeah. Oh,
I was just having a good time at the party.
There you go. Nothing wrong with that.
And, before we dive right into the topic, Cliff was talking during Swap Shop about the benefit of being, among the last callers and the last person that's heard and will be remembered through the weekend. Cliff was talking about the doctrines of primacy and latency. Did you know that, Cliff?
No.
Of
Cliff
what?
says no. Primacy and latency.
Gesundheit. Can you say that
God
on the
bless
radio?
you, yes. Trial lawyers have learned this a long time ago. What a jury hears first sets in motion their perception of the case throughout the trial. So psychology tells us that if you are able to reach the jury in your opening statement better than the other side, evidence that they hear throughout the trial that disagrees with what they are now beginning to believe, it doesn't process very well. Evidence they hear that agrees with what they're beginning to accept from your opening statement becomes cemented in their memory.
That's
So
interesting.
that's the doctrine of primacy, and we'll hit Paul in line 1 in a moment after the doctrine of latency or recency. It's the opposite. It's in closing arguments, let's say. The last thing the jury hears is the most powerful. It's your last effort to alter their perceptions throughout the trial, alter whatever they may have decided from the opening statements, or to reinforce it. So lawyers consider both the first and the last as the most important aspects of a trial. So when you're setting up your list of trial witnesses and trying to decide, well, what order do I want these people to testify? You will generally find the stronger witnesses at the very front and at the very end, with everybody else mixed in the middle. And that's really it's more psychological theories than legal theories, but that lawyers have adopted as an effort to sway a jury.
I remember in the L.A. Raiders antitrust lawsuit against the NFL, Joe Aliotto made an amazing closing presentation that wound up hanging the jury. So, because it was going the other way. There was no doubt about it. It was going the other way. And then, Joe was simply amazing in that close.
That happens very well. That it's not unheard of, and so I guess Cliff is chatting about it on Swap Shop, and I guess he didn't realize he's talking about these great legal and psychological theories.
Wow.
He knows these doctrines, and he doesn't even know he knows these doctrines.
Oh, my.
Cliff says he knows a lot of doctors.
There you go.
All right, so. Oh, I'm sorry, Paul. Line 1. Geez, I'm sorry. How are you doing?
I'm doing fine, Counselor. Thank you for your program.
Oh, you're welcome. Thank you for listening. How can I help you?
I hope you can answer this. I recently did a refinance on my home, and the previous mortgage company paid my St. Lucie County taxes. But when I closed with the new mortgage company, they took the money out to pay the taxes too.
Okay.
St. Lucie County says when the second check arrives to pay, we do not accept it, and we send it back to the company that sent it.
Okay, that's interesting. I had not heard that before.
Well, I called them and spoke to them. I said, when it comes back, I want you to send me the check to my address. Oh, we don't do that. What do you do with it? Well, we put it in your escrow account, and then at the end of the year, after we reestablish your new escrow, and there's leftover, then we'll send it to you.
All right, now that's very interesting because the first thing that I would think of is you put your request in writing to them because you've double paid.
Right.
And I don't see any good reason why you should have to double pay. I don't see any legal reason why you should have to double pay. In fact, the second mortgage company should have ascertained ahead of time before closing whether or not your taxes were paid. But
what they told,
go ahead.
Go ahead.
I was going to say, but the only caveat I'm thinking about is what is actually written in your loan agreement. Because the loan agreement establishes the parameters for the escrow account. And if the loan agreement...
You'd have to see that. Yeah, you'd have to see that.
Right. This is why attorneys sometimes say, I need to see the document. Because if it permits what they're saying they're going to do, then that's the contract you entered into. If it doesn't, then I think of no reason why you're not entitled to that money back right now.
Yeah, why would they want to put a complete tax bill back into my current escrow?
Why? Because they'd love to hold on to it and earn interest.
And they'll charge fees.
That's what I'm worried about.
Right, yes.
They'll charge fees.
Yours may not be more than a trickle in the pond, but when they do it to 10,000 people, they make some money.
Right. And I have a feeling they never intend to return that complete tax money to me. That's what I believe.
So you would need to really look at your escrow papers and see what it says, or if you're able to read it, that's wonderful. If it's gobbledygook, then you need to call a lawyer.
So if I call and make an appointment with you and bring the complete
Sure.
documents to you, you can figure that out?
I would certainly hope so. I would certainly think that by looking at your loan agreement, I would be able to give you an answer to that question.
Okay. Am I right in thinking they don't ever want to give it back to me?
It's a big business, so I would say you're probably not lying and thinking they would prefer not to give it back to you. And if they're obligated to give it back to you, it's sort of like insurance. Insurance, when they're obligated to pay and they sometimes deny coverage and you got to fight for it, they know that a certain percentage of people are going to give up.
Right.
Your mortgage company may know you're entitled to it back, but give you some cockamamie explanation that sounds good, and figure a certain percentage of people are just going to drop it. So looking at the document and knowing what your rights really are is a benefit. Of course, to be honest, it costs money. It costs money for the consultation. And then what I will typically tell a person is, if you feel comfortable yourself based upon what I've told you and bullet points I may have given you, to write a letter to the company so that, you're not paying me to do it right away. You're taking the consult information and you're using it for your own benefit. that's great. Now, sometimes I have people come into my office that don't even have a high school education, and they're not comfortable doing anything like that. So now the issue becomes, okay, do you want to retain me to do it? And, it costs money. So, it all depends. You sound like an intelligent guy. I suspect that, if I said, well, Section 213 of your mortgage says this, you may want to tell them that doesn't authorize them to take, this tax money. You could probably write a letter.
Okay. I'll call your office.
All right. It's 781-8003, and Claudia is standing by for your call.
Thank you, Tom.
You're welcome. Take care.
And she's got a 24-hour number. So
No, only during working hours. I think we have Patrick on line 3. Hello, Patrick.
Whoop, Patrick's gone.
Patrick sounds very much like a old-fashioned busy signal.
Very much gone, yeah.
That's an interesting voice. I have not heard that before. It's been a long time since I've heard a busy signal.
Yeah.
So, Patrick, if you want to call back.
Call back.
It's 340-1590. Be happy to talk to you. Maybe I took a little bit too long with Paul, or even getting to Paul. All right.
Well, hopefully he's not with Joe and Willie's mortgage of Ocala or something,
All right. So
that's a very interesting question.
It is very.
It's, oh my.
Well, my mother is still giving me instructions on Facebook Live. I should repeat the question. Guys, you got to get that new equipment because, I'm getting blasted every show. All right, Mother, and whoever else is listening. The question was that the gentleman had paid his taxes through his mortgage company. He refinanced his mortgage, and the second mortgage company also paid his taxes. St. Lucie County said, well, we're going to send the second check back when we get it. And now he wants that second new mortgage company to give him the money. And they're saying, no, we won't give him the money. We're going to put it in your escrow account, and we'll see what happens at the end of next year. And he wants to know if they can do that. And this is precisely one of those situations where a lawyer has to look at the legalese in the document to tell him whether they can or they cannot. Are you satisfied, Mom? Okay. All right, we do have Patrick back, this time on line 1. Hi, Patrick. How can I help you?
Hi, I'm fine. How are you?
I'm doing all right.
Good.
It's a new year. I haven't screwed up too much yet.
Okay. Just have a question about a landlord-tenant situation.
Sure.
Just seems like the landlord holds all the cards when it comes to doing things. I've had a situation where my neighbor complains a lot about different things in my yard, and the shrubbery's not cut, trimmed, and all that.
Okay.
At the same time, the landlord has been asked to fix 7 or 8 different things around at the house. It seems like, they're more concerned about anything that I do. For example, I had a call from him saying that he wants me to trim my hedges.
Right.
And it's because the neighbor complains.
Right.
Which he has issues with me. But what kind of leverage does the tenant have when it comes to the landlord's responsibility to fix things around?
All of that is set forth in the Florida Landlord-Tenant Statute for residential tenancies. The landlord rights, tenant rights. Let me sort of summarize. The gentleman is wondering what his rights are. He has a neighbor who's complaining to his landlord, being very picky. The landlord is asking him to make changes while he's asked the landlord to make repairs, and the landlord hasn't done it. So what can you do? First of all, the landlord, being receptive to the neighbor, I've heard that a lot, but unless you're doing something that is contrary to your lease or would constitute a nuisance under local code, there's not much a landlord can do to you if you don't make the fixes he asks. If the code does not require the shrubbery to be any lower and you don't lower the shrubbery, there's nothing the landlord can do about that. Now, if you're creating a nuisance, I have a case right now, for example. if you're blaring your stereo system at 3 in the morning, then the landlord could do something and move to evict you after giving you a notice about the breach of the lease, breach of the noise ordinance. On the other hand, for you, you're complaining that there are certain things you're asking the landlord to do and he's not doing. Some of that you might have legal rights, some of it you might not. First of all, Florida statutes specify in very short form what things a landlord must do in terms of repairs. Just by way of an example, I know this is Florida, but the landlord must provide heat. Doesn't say anything about air conditioning.
Wait a minute, back up.
The
What?
landlord must provide heat. That doesn't mean you have to pay for it, but the heat has to be working.
Oh.
So, the landlord has to do a number of other things according to statute. The landlord may also have agreed to certain things in your lease agreement. Most lease agreements spell out, all right, the landlord, I'm responsible for repairs of the appliances. I'm responsible for, this, that, and the other thing. And the lease may say the tenant, you're responsible, for any repairs that don't exceed, $200 or something like that. So once again, we have two documents that are important to look at. One is the Florida statute, and one is your lease. Without knowing precisely what you're asking the landlord to do, I don't know if you're able to force the landlord. Let's assume you can. Let's assume it's one of these things that the landlord is required to do either under the lease or under statute. Then your leverage is to send a 7-day notice to the landlord that specifies the deficiencies, the repairs that are needed. And if the landlord does not make those repairs within 7 days, you have the right to declare the lease terminated. Now, that could lead to litigation, of course, but you have the right to say the lease no longer exists and, I'm leaving. So if you have 10 months left on your lease, you leave, and the landlord may want to fight over those last 10 months. But under the statute, if you properly gave notice about proper things that the landlord must do, then you have the right to terminate the lease. Other than that, you don't have very much leverage.
Well, I kind of figured that it's a situation where the air conditioning, for example, is not very efficient in the living room area. The difference in the temperature between the bedroom area and the living room area varies somewhere between 5 and 10 degrees, and that can be very hot in the summer.
Oh, I can appreciate that. That's for sure.
I've done that for years, and there's electrical outlets that don't work. Rear back sliding door that's very, very hard to open.
Okay.
You don't even use it because of that. My thing is that he wants to get on me about trimming some hedges because the neighbor's complaining, and he won't even do those things.
And I understand, like I say, but he can get on you, but he may not have any recourse, if you're not violating something. As to the things you just mentioned, the air conditioning, of course, is not a requirement unless it's in the lease. Only heat is a statutory requirement. The rear sliding doors, I can tell you, is not something he's forced to repair unless in the lease it says he's going to be responsible for it. Now, the electrical outlets may be another thing. I'm not certain, but something with regard to that may be in Florida statutes.
The code enforcer has been there, and I've made sure everything is up to code. They don't have any issues with my outside. They inspected it and everything.
Then I would, as to what your neighbor's complaining about, I would politely tell the landlord in writing, leave me alone. I have a right to enjoy these premises free from your interference. And according to code, I'm perfectly okay. So shut up.
All right.
And if the landlord doesn't, then you get closer and closer to having rights in terms of, sending a notice and either, terminating the lease or threatening to terminate the lease, or.
Well, when you say terminate the lease, then that means I got to leave.
Oh yes, that's what it means.
Yeah. Okay.
No, it doesn't mean you get to stay there for free.
No,
But,
I understand.
But there are a lot of people that call me that would love to get out of their lease, and this is one of the mechanisms I discuss with them.
Okay. All right.
All right.
Thank you.
You're very welcome, Patrick. Thank you for listening.
Well, now would code enforcement have something to say about interior electrical outlets that aren't working?
If the electrical outlets violate the code, then yes. But now the question becomes, does the tenant or the landlord have to make that repair? And that's very often decided based upon the lease agreement, if it's not in Florida statute.
Gotcha. Okay.
All right, I don't know if this is my mother or somebody else, but we have Goldie on line 3. Hello, Goldie.
Hello?
Oh, my goodness, yes it is. Hello, Mother.
Yes, I have a question.
All right, go ahead.
Okay, about 2 months ago, I had a new garage door.
Mother, turn the radio off.
Turn the radio down,
I don't
please.
have the radio. Oh, I have to turn you off?
Yes, you got to turn me off and just listen to me on the phone.
Okay. About 2 months ago, I had a garage door put on in my home.
Yes, I know that.
Ever since the garage door was put on, my garage thing opens other people's garages.
So it's a
and
different
vice
frequency
versa.
issue.
Pardon?
It's a frequency issue.
Yes, okay. Now, is the garage company responsible for that? Because they want to send an electrician to change the modem, and they want to charge $350.
No, I would think that part of them installing the new garage door would be to ensure it's on a frequency that is likely least used by anybody else nearby. They have ways of determining that. And so I would think that if you're on a common frequency and you're opening up other people's garage doors, they should be coming out to change the frequency. It has nothing to do. It has nothing to do with the motor. It really is a simple fix. It's a matter of a couple switches, that they'll probably be in and out in 30 seconds just to change the frequency.
They said they're not responsible.
Well, then I think you may need to have a lawyer write them a little letter.
Do you know?
Okay, I guess I'll have to go get me a lawyer and write a little letter because they refuse to do anything about it. I told them that my old garage door was in for 16 years, and I never had this problem. And ever since they changed the door, we're opening garage doors, and people are opening ours.
All right. Well, I have a funny feeling they'll be getting a letter on my letterhead.
Okay, very good. Thank you very much.
Now, Mom, there is a consultation fee.
Oh, okay.
And the consultation fee is either a set of meatballs or
Can't
some
do that right now
or
with
some
one
chocolate.
hand. I cannot make meatballs with one hand right now.
What about chocolate?
We'll settle for chocolate. We
All
got
right.
lots in the house.
Thank you for calling, Mother.
Oh, you're very welcome, sir, and we'll be in touch so that we can get that.
Oh, I'm sure you'll be in touch. Yes.
Goodbye.
Bye-bye.
Well, she's not locked in the house. All she has to do is hit the garage door.
So now I wonder, does that make me more or less credible that my mommy called? I mean, I'm 59.
Hey,
Thanks, Mommy.
You're so lucky to still have one.
Yes,
believe me.
I am, and I was actually talking with my girlfriend yesterday. Her granddaughters have 2 sets of great-grandparents that are alive.
Wow.
And, they're young. They don't realize how fortunate they are to have a chance to get to know their great-grandparents.
Yep.
A lot of kids don't get a chance to know their grandparents. I didn't get a chance to know my mother's father, my grandfather. By the time I was a young boy, he was already very ill. People don't realize sometimes how fortunate they have it.
Yes. No, you're right. You're right.
And when you lose it, in about, this is the 3rd of January. In 2 days, my father will have been gone for 10 years. See, now I'm choking up.
Yeah. Well,
He would have enjoyed listening to me on the radio.
Yeah. Yeah.
It would have been a kick for him.
Yeah.
Okay. When you lose something, particularly a person, it doesn't go away very quickly. As we tell people, the harsh emotional pain passes, but the loss never does quite pass.
No. My dad passed away on his birthday in 1980. 1980.
Okay, almost 40 years ago.
I was back at ESPN, and I can remember that phone call to this day when Carol called and said, "Your father is gone."
Yep.
And it was, I was like, oh my goodness, yeah. You never get over that.
No, these are tough things, and I've had to tell several people that, people that were important to them have passed. It's not an easy thing to do.
No.
So when police officers have to make that, call or in person, that must be tough. And, these military officers that are assigned to make those notifications, they're trained precisely what to say it, how to respond to grief, and how to quickly get out of there, because the military doesn't want them getting involved in the emotion. It's supposed to be a notification, expressing condolences and gratitude for service, and giving information that's necessary, and leaving, because they couldn't really do their jobs if every time they made a notification, they became emotional wrecks. So it's a tough thing. Anyway, so we're halfway through the show, and what was my topic for today?
I have no clue.
It was, what laws went into effect in Florida 2 days ago? On January 1st.
Normally there's a litany of news stories on that.
There have been.
There have been. Okay, I missed them.
There have been. So I figured with whatever time we have, I have 11 new laws in Florida.
Oh, man.
And there's a lot more than that, but I have 11. Let's go through some of the bigger ones, and if we don't finish them, hey, we'll do it next week. What is the biggest one, probably? Texting while driving.
Yes, sir.
During the last 6 months, the texting while driving law has been in effect in Florida, but the Florida Highway Patrol, most sheriff's departments, and most police departments have been giving warnings from July 1st through December 31st to educate. As of January 1st, 2 days ago, no more warnings. You're getting a ticket. And texting while driving is now a primary offense. So it used to be they could pull you over if there was another offense, if you had a bad brake light, if you went through a stop sign. And then in addition to that primary offense, if they had seen you texting, you could get a ticket, but they were giving out warnings. Now it's a primary offense. If they see you texting, they pull you over for that and that alone. And now the consequences are pretty severe. And people may not realize that because they hear, well, if it's your first offense, it's a fine of $30. Big whoop. Your second offense, it's $60. Who cares? Let me tell you something, folks. You better care. And that includes me. I better care and modify some of my own practices.
Are there points associated with those? There you go.
Let me tell you, during the last 6 months, all the police forces, all law enforcement across the state have given out 1,220 warning citations. Imagine if those were tickets.
Well, that's actually pretty low, I would think, with all the drivers in Florida.
As of now, you folks, you can still use your phone's Bluetooth-enabled GPS. You can make hands-free phone calls and read emergency messages, such as weather alerts, Amber alerts. You can also still text behind the wheel at a red light when you're stopped. But you better not be texting while driving. And one other exception. You cannot have that phone anywhere visible, anywhere near your ear. You cannot be operating that phone in a school or a work zone. Or end a conversation, that's a ticket. And it's a bigger ticket. Okay.
What about phones that are mounted on the dashboard?
That's okay, because the phone is not up to you. You're not using the phone.
Okay.
And, certainly you can't be texting and touching it if you're seeing,
Right.
I mean, sometimes I dictate to Siri. I guess that's okay because, what are you going to see? Me talking to myself? I could be singing a song. So for the first offense, as I mentioned, It is a $15 ticket. I'm sorry, it's a $30 ticket. And no points on your first offense. However, the real cost is much higher, and we will get to John in a moment. I'm going to give you an example from Brevard County. St. Lucie County is within a few dollars, very similar. You get the $30 civil penalty. You get another $18 for court costs. $3 to the Brevard Police Testing and Certification. $2.50 to Civil Traffic Court. $3 additional court cost clearing trust fund. $2 to local law enforcement education. $30 to the Court Facilities Fund. $5 to the Driver Education Safety Trust Fund. $3 to Teen Court. $12.50 to administrative fees. $10 to Article 5 assessment. That brings your $30 ticket to $119.
Wow.
Now, it is very similar in St. Lucie County. It's $113. But that's not all! You ever watch late night TV? In addition to those lovely penalties, insurance surcharges. Now we hit you. Okay?
Uh-oh.
Texting and driving, let's see. Data compiled by The Zebra, the nation's leading auto insurance comparison site in Austin, Texas, shows that a first ticket in Florida would boost your insurance rate by 25%, or on average $509 for 3 years.
Oh my.
So that brings your total first offense to $1,650 in real cost. That's a little bit different than the $30 you were hearing about, I think, for most of you.
Yeah, I would say so.
Now, we're not the only ones that are doing these insurance surcharges, and actually, our surcharge, which averages about 25%, is on the low side. In California, the surcharge is 45%. In Ohio, Indiana, New Hampshire, and Rhode Island, it's 34%. Massachusetts, it's 44%. Maine is 29%. At 25%, it's not bad, but boy, oh boy, is it big. So I'll be honest, I certainly don't want to be texting at all while I'm driving anymore, even when I think I'm being safe about it. I don't feel like paying that kind of money. Now, your second offense comes with, a $60 fine. But don't forget all those other costs. Don't forget the insurance surcharges, which are probably going to be even higher. Okay, more than the 25%. And 3 points on your driving record. If you are ticketed in a school or a work zone, it's an automatic 2 points on your license. And if you're texting and it results in a crash, 6 points on your license. And just imagine what the insurance surcharges will be on that. So the texting...
Try cancellation.
Yeah, the texting while driving law that's been in effect for 6 months and is now modified to really be enforceable as of January 1st is a very significant new law in effect in Florida, and one which most of us need to pay very careful attention to, because the error of violating this law is very costly.
You have seen the television commercials with the automatic things in the cars
Yes.
from various insurance companies. So they would probably be able to pick that up right away, I would think. If something
That you're texting?
Well, not that you're texting, but I would imagine that would make it easier for the police department to be in touch with the insurance companies.
Well, in order to get any information like that, they probably need a subpoena.
Yeah, right.
But I get your point. I mean, look, my kid who's about to get his permit, I've held off for 11 months because I just didn't think he was ready.
It's a scary proposition.
He knows that when he finally gets his license, I'm going to install one of these devices that tells me by text message if he's exceeded the miles per hour limit that I've input, if he's hard braked, All these things are now available. The technology is great.
Yes.
He knows that he better not screw up while he's driving when he finally gets the privilege, because I'll be getting text messages. And if I don't like what I'm seeing, I will set a geofence on the car so that now he can't go beyond 5 blocks or something. And I can keep narrowing it so now he can't get into the dang car. Technology has given us wonderful opportunities to install things in the vehicle if we so desire. And, just like I was telling my son the other day, I gave him my old iPhone for Hanukkah, my old iPhone 10. And, I said to him, I could install a parental program called M Spy. You would never know it's on your phone. It wouldn't show up.
Never heard of that.
And I would get a text message every time you sent a text. I'd be able to read your text. I'd be able to see your Snapchats as they're happening, your Facebook posts, your Instagram posts, any new contacts you add to your phone, I'd know who they are. It is a 100% parental spy. Now, I said to him, as a parent, and I think every parent, you got to walk a fine line between safety and privacy, because you don't want to so violate your kids' privacy that they no longer trust you. On the other hand, especially if you have some reason, you need to keep certain tabs on them to make sure they're safe. And safety is more of a parental obligation than having the kids like you.
Very true.
And so, I was honest with him. I said, look, I don't ever want to install this device on your phone. If I ever did, you'd never know it until I busted you, and then you'd realize that there must be something on your phone.
Are you a parent or a pal?
Well, I'm a parent, but I'm a parent who wants my kid to trust me enough to come to me with anything.
Yep.
And, it's one thing he knows that, if I call him out, I'm going to look at his text messages. He knows that could happen. It's another thing to be doing it surreptitiously all the time. That I think you would lose trust in.
I would think so, yes.
So I told him it exists. I don't ever want to use it, but don't give me cause. As for the driving, I'm going to use it. That is an absolute matter of safety. If I find out you're driving 87 miles an hour, you ain't driving for a while. Okay? Because as I've tried to explain to my son, you could be the most careful driver in the world. The problem is you don't have the skill and experience to be the best defensive driver. It's the other person that you worry about. And now as he sits in the front seat often, I try to give him little lessons like I'm driving and I say, see that car in the lane to my right? I have a feeling they're going to cut into the left lane. And sure enough, they do. I said, that's just from experience. I just saw something. I had a feeling, okay? And if you're not aware of that, then it surprises you, and guess what? You have a rear-end collision. If, I see somebody that is not paying attention, I want to get as far away from that car as possible, because who knows what's going to happen. If I see a little bit of weaving, a truck on the highway, I will get into the left lane. I'll do 90 if I have to pass that truck and then slow down, because I don't want that truck weaving into my lane and I have no room to my left to do anything. So my defensive driving is to accelerate and get away from the danger. So, you try to teach lessons before they ever get behind the wheel, and that's what I'm trying to do, to make him aware that driving is not just you know how to drive. Driving is constantly scanning the road with your eyes, constantly thinking of what some idiot might do. And even if it doesn't happen, being prepared that it might happen so that when the few times it does happen, you're not so surprised and you just, I knew that was going to happen. And, that could save an accident or 2 or 3 or 4, who knows. I know that, anticipating certain things has saved me from accidents.
Well, and it's interesting because our son in Los Angeles has always done public transportation. He always felt that he was a little flaky enough behind the wheel that he wasn't comfortable. So he just doesn't drive now and hasn't for a long time.
And they have good public transportation there, so that's possible.
Right.
What are you going to take here?
Right, exactly. Yeah.
You know,
Yeah.
that's a different trade between living in the city and living in the suburbs.
Right. Yeah.
You know, when I went to visit my grandmother in Montreal, the bus stop was right in front of her house. As an 8-9-year-old, I'd hop on the bus. You know, my parents told me, let's say if I want to go to the movies, take the bus all the way downtown to the last stop. It's a terminal there. Right across the street is a shopping plaza that has the movie theater in it. When you're ready to come home, you just cross the street carefully, look for the 102 bus, and that'll bring you back to your grandmother's. I was given that freedom in Montreal when I was relatively young because in the late 60s, early 70s, Montreal was such a safe city. And public transportation, whether the bus or the subway, was so clean, immaculate, and safe that they felt it was okay to send me to the movies by myself on the bus. Would I ever let my kid do anything like that? Not a chance. We live in a different world.
Yeah, times unfortunately are different.
You know, I was always told, if you're lost, ask a stranger. Imagine that. Ask a stranger. Not the advice we give today.
Stranger danger?
Yep. Did not exist back when I was a kid. You were told to go to a stranger. If you're lost, you know, they'll help you. You know, different place. All right. Guess what, folks? If you are one of those people who make the minimum wage here in Florida, your minimum wage went up slightly as of January 1st, from $8.46 an hour to $8.56 an hour.
I got a raise?
10 cents.
Awesome.
There is a law in Florida that is, well, there's a bill in the legislature to gradually increase the minimum wage until it hits $15 an hour. It is not yet a law. So we have a 10-cent increase in the minimum wage for now.
I thought every state was going up to 15.
Not that I know of.
Okay.
And if you are an employee that gets tips, like a waiter or waitress, your minimum wage has now gone from $5.44 an hour to $5.54 an hour, big whoop, plus tips. Okay.
Ouch. Okay.
All right, smoking. 21 as of 2 days ago.
Good.
Can no longer smoke in Florida at the age of 18. Smoking or vaping products cannot be sold except to people 21 and over.
Good.
Unfortunately, you can still buy a gun at 18 in Florida.
Jeez.
Can you imagine that? You can't buy a cigarette or vape, but you could buy a gun. The insanity in this world when it comes to guns and the stranglehold of the NRA is just amazing. Electronic notarization. It used to be you had to get a document notarized and go to the notary and had to sign that document in person. And then you give your identification, and the notary, like me, stamps it and notarizes the document.
Yeah.
As of January 1st, Florida has passed the e-notarization statute, which allows notaries who go through an extra course and post an extra bond to e-notarize. And what that really means is that the notary can notarize a document electronically with an electronic signature as long as you are in front of that notary by video conference. And they see you sign it, and they see your identification so that they can verify who you are. And then you can e-notarize sort of an electronic signature just like you do in Adobe. And as long as that notary has a unique electronic signature, that can be done. The notary has to keep a record of every e-notarization for 10 years. And can charge up to $25 per item notarized.
Well, our Julie is a notary here. And it's very interesting you say that, because now there are a couple large ad agencies out of Chicago that that require that everything is electronic. So, but they also want their affidavits notarized. So what Carol does is just, and they're fine with it. Just see the stamp, and she emails it to them, and they're fine with it.
She does what? She does what?
Well, as far as, emailing the bills or whatever.
But do they sign in front of her? Don't answer that on the radio.
No.
Don't answer that.
No.
Because if they're not signing in front of her, it's a felony.
Oh, no. Oh, my. Okay.
Except unless you're complying with the e-notarization bill now. But otherwise, not having notarizing a document that wasn't signed in front of you is a felony.
Oh, boy. Okay.
Oh, oh my goodness. I forgot John. And he's calling back. John, I am sorry.
Dear
I
John.
apologize. I got so excited about my own show. I forgot you were there.
Hey, I'm laughing. It's okay. You're giving us a lot of good information today.
Well, thank you.
I did have a question, but before I ask it, you said about the texting, the premiums are going up. What percentage if you're caught?
25% insurance premium surcharge on average.
Wow.
For 3 years.
My question is, man goes into a hospital in December of 2014, 5 years ago. He has Medicare, and the doctor mischarged it, so Medicare didn't want to fix it. Long story short, it goes to collection. Collection harasses the daughter of the father who was in the hospital for 5 years, and now they send a letter with the correct amount. Now, collection agencies, they just don't do it out of the goodness of their heart.
No, they do it for a fee.
Yeah, so nowhere on the letter does it show a fee. It just shows the corrected amount for the doctor bill from 5 years ago.
Well, it's not going to show a fee because the collection agency fee is a percentage they've negotiated with the person who holds the debt, that if I collect $1,000, I'm going to keep $200 of it, let's say.
Well, this is a $73 bill.
A $73 bill.
Oh, God.
After 5 years?
Yeah.
You want to know something? I would send the collection agency a letter under the Fair Debt Collection Practices Act that simply says, do not contact me any further. I dispute the debt. The only contact that you should have with me is to initiate the lawsuit, which would be in small claims court.
That's just it. I looked up the statutes for my friend, and she's really not liable anymore because they never sued the father, who has since passed away, and she's not liable because of the statute of limitations. Apparently, the collection agencies only have 5 years.
Well, that's a good point. If the statute has passed, then they're not liable. Very often, they will still try to collect, because if you pay them a single penny, the statute starts up all over again.
Yeah, I know. That's what I'm telling her. I'm saying I don't think you should give them a penny. But,
No. I think you basically send a letter saying, stop communicating with me, except to sue me under the Fair Debt Collection Practices Act. And by the way, the statute's run, so go away.
Yeah, because to me, it's just amazing that after all these years, they're still going after her and the father for $73.
Most collection agencies would give up after a period of time because they're not making their money.
Well, that's what I thought. But the thing is, I can't understand how they make money on $73. They would probably collect the whole thing.
I don't know. They're doing it as a volume business. That debt collector that they're working for, they may have 5,000 of their debts, and they're not really caring about the $73 fee itself. They're caring about the client itself.
Now, if there was a judgment and for some reason my girlfriend never got noticed of a judgment or never got noticed of a court date or any of that stuff, they wouldn't be sending this doctor's bill. They probably have a judgment, right?
Absolutely, that's right. They would not be doing that. They'd be pursuing you on the judgment.
And wouldn't they have to send a certified letter if they were going to sue her or the estate?
No. No,
But
they don't. They don't have to give you any notification. They can just sue you.
Well, how do you get your day in court if they sue you?
Well, you have to be served with process. You have to be served with a summons and complaint.
That's what I mean.
Oh, that's the notification. Right, they don't have to notify you before they sue you, but once they sue you, they have to serve you with process. If you don't get it within a certain period of time. Yeah.
Either a processor or certified or just a processor?
It all depends upon what court you're in. For example, in small claims court, the court sends out the notices itself. County court, I'm not sure. You may be able to do certified mail. Circuit court, you can't.
So circuit court, definitely you're going to get a processor knocking on your door.
Yeah. But for
And if they
$78,
can't
it would be small claims court.
Okay. But if it was a judgment, she would have heard by now.
I would think so, and you could certainly search for judgments and find it. You know, it's a long time, but if notice wasn't given, there's always a motion to vacate a judgment, you know, for failure to serve process.
Yeah, and you can search that on the court
Yes.
clerk's website. Yeah. Okay. Well,
All
thank
right.
you, sir, and
You're welcome.
all the good information.
Thank you. All right, so we're running really short now, so let me quickly tell you one other big change, and we'll get to some of the others next week. You know how you go to the doctor sometimes, and depending upon what the prescription is, they either send it in electronically to the pharmacy, or sometimes they give you a hand prescription. If it's a narcotic or a certain scheduled drug, you get a piece of paper you have to take to the pharmacy. They can't send it in electronically. Makes no sense to me. I would think those narcotics would be the things that send in electronically, because giving you a piece of paper allows you to sell it to somebody. But no, the legislature in its infinite wisdom reversed it. As of January 1st, all prescriptions are now electronic. They must send them to the pharmacy electronically. There are, of course, like any other law, the good old exceptions. I'm going to give you just really quickly 4 of them. If the doctor determines it would be impractical for you to obtain a drug prescribed by electronic prescription in a timely manner, they can give you a hand prescription. If it's for a drug that the FDA requires a prescription to contain items that are not statutorily permitted in electronic prescribing, they can do it. If you're in hospice care or a nursing home, they don't need to do it electronically. And the last one, if the doctor determines it's in your best interest to have a paper prescription so that you can compare prescription drug prices among different pharmacies, they can document it and give you a hand prescription. Otherwise, it's electronic. I'm being told that's it for me. I'm being cut off. This is Stuart Address. This is Ask a Lawyer. Thanks for those who called. Thank you for listening. I'll be back next Friday. Enjoy your weekend. Enjoy your week.
Happy New Year, WPSL,
Happy New
Port
Year.
St. Lucie.